I will now call 126718 in the interests of K.W.D. and E.L.D. minor children. Counsel? May I come, Smith?
Good morning, and may it please the court. I'm Jennifer Martin Smith. I'm with the Alderson Law Firm here in Topeka, and I represent the father in this case. I find it a little bit easier to refer to him as father rather than by initials, and so that's how I will refer to him through the arguments. Just a brief factual summary. This case was filed in Leavenworth County in 2021, and father, my client, had begun serving a 5-year sentence a year and a half before in 2020. And it was for aggravated battery and domestic violence. It appears that after he had been away for some time, the mother began using some pretty hard drugs and left the children with the father's mother. And there were 3 children originally in this case. My client is only the father of 2 of them. But it appears that the allegations were that the grandmother, the paternal grandmother, may have smacked or hit that other child. That was not my client's. But from the time that he went into prison in 2020, he had been having weekly phone calls with all 3 kids, his 2 children, as well as the stepson. And once this case was filed, he continued having those weekly phone calls until the foster parents stopped them. By the time this went to trial in November of 2022, and then we had the decision in December of 2022, he had a release date, an earliest release date of December of 2023. And he, in fact, was released at that time. And I'll proffer to the court that as of this morning at 8:30, he was still out, and he was still following all the conditions of his post-release supervision. The boys in this case are now 7 and 8. And at this point, we would certainly challenge that there was insufficient evidence to find the father unfit under the 3 provisions that the district court found him unfit, which were KSA 382269, B5, B7, and C3. And I recognize that in the Kansas Revised Code for the Care of Children, one factor can be used to determine a parent unfit. But I think in this case, we have kind of this outlier opinion of In Re TH from 2021, where in a very similar situation, a father went to prison, was going to be in prison for a significant amount of time, but he had maintained a relationship with his child. He continued to try to provide for the child from prison, and there was no evidence presented that it was in the best interest of that child in TH to have his rights terminated. And we don't have a lot of published case law in child need of care cases. And when I went back and I looked at all of the cases that have come out since TH, I think they're all really distinguishable. I mean, we have, parents who were convicted of sex crimes against children. We have parents who are going to be in prison until well after the child turned 18. When we're looking at whether a parent is unfit, all of the court's opinions, all of the briefs that I've written over the years, they all start the same way. And they all start with a parent has a fundamental right to parent their children unless they are found unfit. And we hold these rights to be so fundamental. But at the end of the day, we have a father here who didn't commit any crimes against his children. He was not alleged to have abused them in any fashion. And he was kind of lumped in when the mother of these children fell off the wagon, and he had a foreseeable future release date. He had a relationship with his kids prior to him going into prison. And it's not like they were babies who had no knowledge of their father, which is, again, in a lot of the cases post TH, what we see, no relationship, no contact. When we talk about somebody being unfit by conduct or condition to render them to care properly, obviously at the very time of the filing of the termination motion and at the evidentiary hearing, he was incarcerated and could not parent his child physically at that time, or his children. But he still maintained contact. He does all of those things that we ask people to do when they're incarcerated, because, we tell them, hey, you may be incarcerated, but you have a fundamental right to parent your child. And so you need to follow your case plan tasks. Well, he tried to do that.
Are you asking us to adopt essentially a rule of law that a finding of unfitness under B5 alone is effectively unconstitutional?
I'm not necessarily asking that you adopt that, no.
So you're not denying that there's clear and convincing evidence that the statutory factor in B5 was met?
Correct.
And so what is left other than a claim that it's unconstitutional to do so?
Well, there is a factual argument under B5, and that was made in the TH case, that factor may not alone be enough, that there has to be other evidence showing that.
Under the statute, what rule of law requires more than just one factor? Like, where do we find that rule?
Well, we don't.
So it's not in the statute, right?
No, it's not.
So it would have to be in the Constitution, or are you asking us to look somewhere else?
No, I mean, it would be a constitutional right. We're saying that parents have a fundamental right to parent their children. And when we look at B5, it just says felony in prison.
So just to circle back to my first question, you are saying that a finding of unfitness under B5 alone is unconstitutional?
Yeah, I think I am. I didn't frame it that way.
And is that a problem for the argument that you?
Probably. But I am asking the court to, under the TH ruling, they said that didn't necessarily mean unfitness. When looking, he tried to do his mental health evaluation. He was told he didn't qualify. He maintained contact until the foster parents shut it off. And I think that is one of the real problems that we see in these child need of care cases, is we let outside people who don't have fundamental rights to their children to decide that, oh, they're just too busy and he can't have contact anymore. We then have to look at, oh, yes.
Number one, you keep saying that the foster parents cut off the visitation,
Mhm.
but is that really what the record reflects? I mean, the change that happened was that he got a job in prison that made it so during, the period of time where he was available, the children weren't available, correct?
Sort of. He did have a smaller window of availability, but the foster parents said, well, we're too busy in the evenings. We can't let you call until 8 o'clock or later. And so at that point, that didn't even really impact like the job that he had, because he has to have somebody there to make the call, his counselors, and they don't work past 4:30. So the foster parents wouldn't offer any other solutions.
Is there anything in the record to show that he could have gone back to the job that he had before?
No, not that I'm aware.
We don't know one way or the other.
No, whether he could have gone back to a different job, no.
Okay, so when I'm looking at this is a really tough case. I agree it's a tough case. And I think Justice Stiegel raised some really good points because, as the statute is written by the legislature, it says that, it really says conviction and incarceration for, I guess, a felony conviction and incarceration. Boom, 4 words, right? And so when you're looking at that, and I know that you didn't argue the fact that it's unconstitutional, but with that aside, as I really dug through the record, if we don't count anything about agency effort, so just looking at felony conviction and incarceration without any agency effort, our law pretty much indicates that in exceptional cases, termination of an incarcerated parent's rights is not warranted when the parent actively engages with the reintegration process. The children are doing well despite the parents' incarceration, and there's a viable post-release plan. Here, I, you know, I would be inclined to, I would be open to the fact that the reintegration plan was really not aimed at him.
No.
There was just a lot of things, it wasn't aimed at him. It was mostly aimed at the mom. They had both had the same reintegration plan. And I would tend to agree that there really wasn't any evidence that the case manager really made reasonable efforts. And I think the Court of Appeals found that to assist Dad. But why did he wait until the TPR to say, hey, these tasks are not applicable to me because I'm in prison. Hey, let me identify tasks that I can and can't complete. And then, basically he waited until the TPR hearing to raise issues and basically treated any kind of interfering circumstances as beyond his control.
Well, I do think the record reflects that he attempted to keep calling the case manager or have his counselor email the case manager to try to figure out how he could get the contact back. And then they were told, oh, well, there's just no way that we can do that. He did reach out for some of the things. I mean, he probably could have done more. I don't dispute that he probably could have done more, but I also think, he's in prison, he's working, he's trying to better himself. And when you're not having a whole lot of contact with the case team, or they're just sending a letter or sending a case plan through an attorney, I mean, he did what he could and he attended those case plans. I don't think he was aware that he could really push back against the agency. I don't think he was aware that he could tell them, this isn't fair. He's told me that since then, but, from his position inside the correctional facility, I think he did what he thought he was supposed to do. And I don't think he was aware, nor was it explained to him, that he could have a say in what those case plan tasks are.
So at bottom, do you think that he engaged in the reintegration process?
I think he did as much as he could. I think he did testify that he was sending money to his mom. He didn't realize that wouldn't go to the children. He was trying to have that contact. When you look at his history of incarceration, the first time he was incarcerated from 2010 to 2013, he had a laundry list of write-ups. And this time when he went in, he promised his kids, like, I'm not going to get write-ups. I'm going to get out. And
that wasn't part of his reintegration process, was it?
Resolving legal issues was part of his reintegration plan. And I think that kind of goes along with that.
Okay. And then, the children obviously were not doing well during incarceration. First with mom, and then with the paternal grandma, then with the first foster family, then with the second foster family. So would you agree that there were emotional and behavior challenges due to instability because Dad was incarcerated?
I think when they talked about the emotional issues with the move and the foster home, I don't think you can attribute that to Dad. They said, that the kids moved from their long-term placement to a new placement because the other foster parent had some medical issues or something. But yes, I think the boys had some emotional issues, but I think those predated his incarceration.
To that end, and this really wasn't brought out, but before incarceration, he said, oh, I didn't know. I never saw mom with a drug problem. Okay. But isn't it true in the record that it shows that because she had a drug problem, he himself took the kids to his parents' house, to his mom's house before he was incarcerated?
I thought that it was after that. My reading of the record was that mom dropped them off with paternal grandmother and just didn't come back. I think they had an ongoing relationship, but my reading of the record was that she didn't relapse until after he went away. And in my conversations with him, that's what he represented to me. And so if I've missed that in the record, I apologize.
I think there was a conflict in the record that he
Mhm.
said that and he testified to that, but there was also in the record, but I'll double check that. And then to that end, and I think this is important when it goes to unfitness. Would you agree that dad did not have a suitable post-release plan to properly care for the children? He intended to live with his mom, who was previously deemed unsafe because of credible reports of physical abuse. And then he provided no testimony about how he would care for the children once released, physically, financially, or otherwise, except to suggest, while he testified, mom would be involved because he believed she was a good mom and he would be able to stop her from abusing drugs and attend treatment.
I think that his plan was he was going to get out. And then, yes, he was going to live with his mom for a period of time because he didn't have anywhere else to go. But that would have given the agency time to work on that plan. He could have resumed visits with the children. They didn't have to be at mom's house. It could have been in the community. They could have been at the agency. And then
Why couldn't he work on that plan while he was incarcerated?
I think he should have. I don't think it was something that was brought up to him. I mean, his plan was he was going
It's
to
part of
get
the reintegration plan.
right. And so he was
So
going
then
to live.
again, did he actively engage in the reintegration process? Or was he just passive?
I think he engaged as much as he knew how. I think he did. He tried to maintain contact.
Is that the standard?
That he engaged as much as he can.
No, as much as he knew how.
No, it's not. But what is the standard? I mean, that's kind of an amorphous question. I mean, what else could he have done?
If the reintegration plan says, what are your plans for taking care of the children when you get out?
Well, and his plans were that he was going to have a place to live. He was going to get a
With his
job.
mother,
Right. And as soon as he had saved up enough money, he
who
would have
was a
gotten his
child
own
abuser.
place. I don't think she was substantiated necessarily.
Yeah, it was.
But I mean, he wasn't planning to live with her forever. I mean, there was just a period of time where he had to get his feet under him while he worked on that reintegration plan. He could have had those visits. They could have had longer, day
And
visits.
then he was going to incorporate mom into the whole thing.
He was saying that when mom is sober, she's a good parent, and he was going to allow her to have contact if it was safe and appropriate. I don't think anybody was asking him to completely cut her off unless she was unless she was using. And I don't think that was really his plan. He wanted mom to be involved because when she is sober, she's a good parent. And we want parents to continue to have safe relationships with their children, as long as she was sober.
Thanks for answering so many of my questions.
No, that's all right, Justice Stewart. Thank you. I'm out of time, but I'm happy to answer other questions if the court has any. Otherwise, I will sit down. Thank you.
Thank you.
Good morning. May it please the court. Sarah Ikenna, Assistant County Attorney for the state of Kansas. This case is compelling to me, I think, particularly in the numbers. And I think the fact that father had been out of the home for 18 months before the children were removed from the home is compelling. And I think the fact that the children 1 and 2, after he was removed, they turned 2 and 3. Before he was incarcerated, they turned 2 and 3, but they were 1 and 2 at the time when he was removed. It was 29 months after the children were removed to his release. And counsel is talking about the fact that there are things that he could have done, that he could have resumed visits, that they could have lived, stayed in placement before father was able to reintegrate. Your Honors, when we look at children's time and the amount of time that these children are lacking permanency, these numbers are compelling.
Can I ask a few questions about the numbers as it relates to the statutory factors themselves? So preliminarily, I think we would agree that under subsection A of 2269, the first 2 steps are a finding of one of the factors of unfitness, one of the statutory findings, and a finding that that condition is, quote, unlikely to change in the foreseeable future, right?
Agreed.
But what I want to ask about B5 in connection with that, and B5 is this conviction of a felony and imprisonment. So clearly, this father was convicted of a felony and imprisoned.
Correct.
So that fact is established by clear and convincing evidence. How are we supposed to look at what makes clear and convincing evidence that that fact is, quote, unlikely to change in the foreseeable future when we have a release date?
I think that part of, and it's part of the likelihood that it'll change in the future, that things will change. I think that it is, to use it for totality of the circumstances to some extent. I think the fact that he had prior convictions.
Well, why does that matter? I mean, this is a very concrete, very specific fact. Have you been convicted of a felony? Are you in prison? There's not going to be much that an evidentiary hearing is going to do about that. You either are or you aren't, right? And then in the foreseeable future, you either are or you aren't. And if you're going to be released within a period of, let's just say 2 years, to pick a number out of a hat, why doesn't that factor fail as a matter of law?
I think that for children to be out of the home, and I think that it's one thing if you have a set of parents and you have one parent that can parent the child, or that you might have an alternative, but when you have children that don't have an alternative other than foster
Why
care.
do any of those other facts matter if we're looking strictly at the statutory factors?
Because I think it matters in that these children in particular have been in and out of in and out of several foster homes, and so they don't have this permanency, and so they're waiting. It's not as if they have a safe place to be where all their cares and concerns are.
Do you think that the factor of unlikely to change in the foreseeable future is contingent upon other facts? Like for some families, it might be 2 years, and for other families, it might be 4 years. Like, that doesn't seem to comport with my notions of fundamental fairness.
No, I don't disagree, and I don't think it does, because I think that.
So where is the line? Like, if somebody's in prison, it would seem to me that the foreseeable future, admittedly, our case law says from the perspective of the children, what's the line? I mean, how do we know?
I think that that's the difficulty. That's the question, I think, is how do you decide what that period of time is? And I think in the case in TH, right, he had a much longer sentence and he had a lot of things set up. He had a bank account. He had a family that was willing to take care of the child.
And that's what confuses me. I mean, the case law and the way these cases get argued, all argue about all these attendant circumstances. But to me, none of that. I guess I'm asking for help understanding why any of those things should matter. When we have a very clear, either you're in prison or you're not in prison. And will that change in the foreseeable future? Like, it doesn't matter what else happens. You're either in prison or not, right?
And I agree with that, frankly. I think that.
What do we do then about subsection F? Because it says the existence of any one of the above factors standing alone may, but does not necessarily establish grounds for termination of parental rights. So I think even 5 isn't an absolute. So there must be some measure of discretion there.
And maybe that's when, in the best interest of the child, and that lesser standard of review comes in, because then we can take in the more subjective factors and talk about what's in the best interest of that child and whether or not this incarceration is going to impact them beyond what the agencies can support.
But I thought the district court didn't just say that your release date from prison would change the reintegration because there were the other problems. His plan was to move back in with the mom and other things, and it was that led to the conclusion that for the foreseeable future, it wasn't just based upon a 10 or 12, 12 to 13 months release date. That was only a part of the calculus here, because because once he got out, there were problems. And so it seems to me all of that goes into the foreseeable future determination by the district court. Am I missing that?
No, I would agree. I think that definitely, I think had he had potentially, and I think in TH, he had a home that he could return to. So I think that's maybe a difference in that this individual did not have a stable plan, and certainly a plan that fit what the agency had asked of him as far as having an appropriate place to return to.
And so we may end up in the same place. But I'm again, I'm trying to nail down in my own mind the legal steps that are gone through to get to the final decision. I have understood it to be essentially 3 steps. One, a finding of unfitness under a statutory factor. 2, a finding that that condition is unlikely to change. And then 3, a best interest determination. And we tend to talk about unfitness under the first 2 steps and termination under the 3rd step. Would you agree with what I just summarized?
I would agree.
So does F that the chief was alluding to, when F talks about termination, is that wiggle room? I'll call it wiggle room or discretion. I've always understood, at least, correct me if I'm wrong, that discretionary portion of the decision comes under the best interests test.
I would agree.
But the unfitness really doesn't have discretion. It's based on evidence. Do you
Yes.
agree with that?
I would agree with that.
Okay. And you have to have unfitness before you even get to best interests, right?
Yes.
Okay.
So that means you would say everybody that has a conviction of a felony is an unfit parent.
I think it's possible. I think that, and I think the issue, and I think the problem is that you have a child who, absent another parent, that parent is incarcerated and cannot care for that child. He's not going to be there for bedtime, for
But
meals.
not all felons are incarcerated.
True.
Um,
And so I think it's the incarceration piece potentially that
but
really,
or the imprisonment,
yes, because I think there are plenty of people that have been convicted of felons. that are-
even if that's for 6 months.
Yes. Unfortunately, yes. Although I do think that the system that we have with child in need of care cases generally span a longer period of time than that. And so I think that part of the issue is that a lot of these cases come in and we do have steps that we go through and their time limits and their requirements. And so I don't know that a 6-month sentence would necessarily be an issue for a parent because I don't know that we have many cases that conclude within 6 months.
Wouldn't that be because it's not it's the condition is likely to change
I would
within the
agree.
foreseeable future?
And they would have the opportunity, I think, to move the needle and to change their circumstances in the pendency of the case. I certainly think that that incarceration is an issue, and I think that it is an important issue. And I think that this case in particular is compelling because these children have had a very difficult time in care. I think that they have moved through numerous foster homes, if you look at the record, and it has greatly impacted them and their ability to thrive. And so I think that while father may now have things in a better position than they were in the beginning of the case, I think that to potentially ask the children to further wait on him, again, is outside of what's in the best interest of the children. It's outside of child's time. I think that there are serious concerns about behavior issues that's in the record, that these kids have serious concerns and issues that they're dealing with. And I think for a parent who's on parole, who is changing his life, trying to get his life established, housing, income, job, all of those different factors, and deal with the issues that might have brought him to his incarceration, to also be dealing with children who have serious issues from being in the situation that parents' behavior placed them in. The children are now 7 and 8, and your honors, I think that it was brought up early about the phone calls while father was incarcerated, and I don't know that it's fair to say that the foster parents cut off these phone calls. Certainly the phone calls ended, and I think that again, it was something that was what was best for the children, and I think that there are numerous avenues for father to have communicated with the children, and I don't know that in the record that I saw that there were evidence of letters. I could
How
understand.
do you mean it was best for the children?
I think that to keep their schedules, they were involved in activities with the schools, and therapies and different things, and I think that those were certainly important things for them to address. And I think also the fact that the children at this point are 7 and 8 years old, and at the time that he was removed from the home were 1 and 2, I think is compelling. I don't know that they would have had the same opportunity to form the relationship that the parent had in TH with his child, because I don't know that there was as much time pre-incarceration for them to be able to form that bond. Not saying that there wasn't a bond between father and his children, and that that's not an important bond, Your Honor, but we do have children that need permanency and have been lacking permanency for quite some time. 2021, when they were removed from the home, but even further when their father was incarcerated and no longer in the home.
Maybe this question's been asked already, and maybe I'll try it in a different way. Is there any indication in the text of 2269 what the legislature had in mind in terms of a definition of foreseeable future? In particular with the, what is it, the subsection B5, conviction and felony imprisonment?
I don't think it is defined. I certainly don't think it's defined to a point that it would.
Yeah, it's not defined, but I just didn't know if there were any other clues in the text, if we were to look at that sort of all together in harmony.
Just the thing, what I would look to is just the best interest of the child. And I think that that standard is what is used, the light that's used to interpret the rest of the child in need of care code in that section. I'm almost out of time. I still have a couple minutes. Judge, if there are any further questions, I would submit to our briefs and thank you for the time.
Ms. Smith? You reserve 2 minutes.
I did, thank you. In just the last couple of minutes that I have, I wanted to talk a little bit about the best interest finding. There was not a lot of evidence on the best interest of these children other than the child time, which is the only guidance that the legislature really gave us on the foreseeability issue. We didn't have a therapist testify about the relationship. The case manager even testified she'd never observed or been present for any of the phone calls. She couldn't really testify about what relationship these kids had with their father. And so I think that, you know, if we get past that unfitness issue and we look at the foreseeability, we have a date when the foreseeability was going to change. And then what was in the best interest wasn't something that was really fleshed out by the district court. But the one thing I really want to end with is I don't know what the court knows about what happens to these cases after. So I've had several appeals over the years where a parent has gone to the Court of Appeals, they've won on a technicality maybe, and they get back to the district court on remand, and the agency says, oh my gosh, your appeal took so long that it's just not in the best interest to have any contact with your kids. And I think the courts need to know that that's what happens. So if the court today were to decide, you know what, you're right, that foreseeability changed in the foreseeable future, and we didn't have a good discussion of best interest, there needs to be instructions going back to the district court that this father have the ability to actually try to reintegrate with his children, because that doesn't happen in the real life, in the real world.
Say that again. That doesn't happen if there's some sort of reversal, and so the time period that is attributed to the appeal works against the parents.
100%. That is exactly what I'm saying. I've had specifically 2 cases in about the last 5 years. One of them, they were like, well, we already told.
We've had, it's analogous to a certain extent. We've had adoption cases where that's the fact, and 3 or 4 years later, we have instructed that shouldn't factor into what occurs here in terms of best interest. But you're saying that is not the case in these types of cases?
Not in sync cases. Okay. Not in sync cases. So
I just wanted to, I guess, one final question that comes along on the heels of what you just commented about, which is essentially a concern that I have and might be shared by some of my colleagues, that when we deal with a fundamental right like this, we have a statute that has so many discretionary cracks in it, I'll call it. So many places where you just get amorphous arguments about, and I'm not sure there's anything a court can do about that. I wanted to get your, I mean, does this require a legislative fix if there's a real problem? Or is there anything a court can do about it?
I think the court can remand with specific instructions that we can then use to hold the agency to the fire. I think that's one thing.
Wouldn't we just be adding provisions to the statute if that was the case?
I don't think it's necessary. I mean, I think some of those provisions are there. Like if you say this parent is unfit and they should have had the opportunity to reintegrate, then we should go back and have a reintegration plan. And I guess what I'm telling the court is, in practice, that's not what happens. And maybe that can be legislatively addressed by saying the district court on remand shall allow a reintegration plan.
Thank you.
Anything further? Thank you to
Thank
both
you.
counsel for your arguments. The court will take this matter under advisement.